At first glance, this sounds like a normal neighborhood dispute. Two neighbors arguing, maybe a couple police calls, that's not unusual. But the moment the sergeant starts reading the numbers, you realize this isn't normal at all. 97 documented police reports, and that's not even counting the calls where officers didn't bother filing paperwork. When law enforcement starts going back 6 years just to figure out where a feud began, that's when you know this situation has gone way beyond a simple disagreement. And then comes the number that shocks everyone in the courtroom.
Likely not an exaggeration. There's many, many phone calls to the police department and other city offices, and I'm sure the court as well. So in the 6 years that he's been here, he's had many, many run-ins with every Riverview police officer and city officials. And we've tried many different things to try to resolve the issues over on Village Street with Mr. Moss and his neighbors. And those included mediation at the beginning and throughout these incidences. Civil infractions have been issued, misdemeanor violations have been issued, arrests have been made, an emergency extreme risk protection order was taken out as well, and mental health treatment. None of these things have made any result in improving the condition on Village Street. So we're sort of just trying to figure out what we can do to resolve the issue over there. And hopefully we can do that.
So, Mr. Moss, was that generally in line with what has sort of transpired and happened since you've been at the property, sir?
I would say it would be a succinct summary of it if that's what you're asking.
Yes. So, sir, I really need to know.
500 to 800 calls a year. Think about that for a second. Even if we take the low end of that estimate, that's more than one call to police every single day over a neighbor dispute. And this is exactly the kind of situation judges see all the time. Two people who refuse to let something go, and eventually the entire legal system gets dragged into a personal feud at 8T. That point, it stops being about who started IT. IT becomes about who refuses to stop it.
Of the court, of the Riverview Police Department specifically, and then even contacting in with threatening words, specifically referencing to Sergeant Herrick that you're going to stick a hammer in his face.
Your Honor, that was the allegation. However, upon a review of the, upon a review of the video, not the video, the audio tapes, it's unclear what was said in that. And Mr.
Okay, where's the audio tape? I'd love to hear it. Where's the audio? Who has the audio?
I had it, but I can't find it. I got it from them. We looked at it, and that's why the offer was made as it was.
Sergeant Herrick, do you have that recording still?
Your Honor, I can find it, but I think it was the prosecuting attorney. I'm not sure what happened in that case, but he seemed to agree that what Mr. Moss actually said on the recording was that he was going to stick a camera, or it wasn't really clear what he was going to stick. So I think the prosecuting attorney made a determination that it wasn't very clear, but they believe that he said camera.
Okay. What about the statement that claims regarding the neighbor that good, that went in response, I believe, to the dispatch, the PD being dispatched, good, that'll save the bloodshed. Was that also said?
Here's what he said.
Why would you think that there would be a necessary reason to contact the police department regarding various landscape items, whether it's from a tree, tree bark, whatever it may be, snow,
I mean, I could handle it myself, but it'd be better if I didn't, because if I did, then that could put me at more risk, I would say. So better I call the police in those situations, which in some instances, if not a lot of them, the police department has agreed with me on certain individual levels. I'm not saying it's every individual within the police department, but there are certainly a few times I can think of where they did agree with me, where it was better that I call them than handle it myself.
And Mr. Moss, I'm not suggesting that Mr. Calipari is without fault. I am not indicating that in one bit. What I am indicating is that the behavior of both you and your neighbor, Mr. Calipari, is abhorrent. Absolutely incredulous. And then it rises to the level of the calls into the police department or elsewhere within the city of Riverview with the voicemails that you may leave or comments that you may say that would represent potential harm or danger to somebody. So do you say that because you intend on inflicting danger or harm on somebody, or do you do it as a way to then elevate the call to get the police department to the scene?
I have to be careful I answer that, because we're getting into the case where you had to refuse yourself that went in front of Judge McNally, and I don't know how much I really want to say about that, or how much I really ought to say about that in light of that. But to answer your question the way you worded it, no, I didn't mean any threatening things. And matter of fact, what you don't have knowledge of is prior to that, on March 21st of 2020, or March 17th, 2021, a couple of days prior to that, my then neighbor on the other side of me, Nancy Vernier, her sons had threatened me. And that's kind of where all that stemmed from, because in fact, I believe it was then Officer Herrick who came to my house and talked to them. And then there was anything else after that, because she subsequently passed away, I don't know, a year and a half later or something like that. I don't recall. So there was no further incident, but it was getting to the point where it was going to come down to physical violence and that. So that's where that came from, actually, with the comments that were made at that time that I'd rather not reiterate. But
I'm talking about these in this current one, Mr. Moss.
Okay, yours for
referring the issue from July 3rd. Yes.
Okay, I'm not certain what the comment was, so I can respond to it from July 5th.
Good, that'll save the bloodshed.
Well, that probably was a reference to what I just talked about, because it seems like to me that this is what Mr. Calipari wants. Why else would he be raising his fist to me? Why else would he be threatening to knock me out? And all this other stuff. I've never threatened to knock him out. I've only threatened to knock him off his bike to a police officer, which I really didn't think would be a crime. And I think in most other places wouldn't be. Like I said, I admit.
Hold on, you don't think knocking somebody off of a bike is a crime?
Well, that's what this is about, because I verbalized it to a police officer. That's the whole nature of this case, as far as I know.
Right, so you don't think threatening, if somebody were to be knocked off a bike, you don't find that that's a crime?
If I had done it, yes, but I don't think threatening, verbalizing it to a police officer. I mean, I get because of the ordinance in review. What I'm suggesting is I don't know that every city, and probably most cities, don't have a similar ordinance to that. Maybe they do, but as far as I know, they do not. And it's far better to threaten to knock somebody off their bike than to actually do it, in my opinion. And I've not even raised my fist to that man. Nor would I.
Okay, so, sir, was the initial frustration that day on July 3rd when you contacted into the Riverview Police Department, was the initial frustration because Mr. Calipari continued to talk to you?
I would have to go back in time to really know the answer to that question. I don't think it had to do with the fact he was talking to me. I think it was more so the fact that he was, if I recall, if that was the day in question, I'm not sure I'm right. He was daring me to swing him if that was the day in question. And I just wouldn't know. He was goading me, in other words. And that's where my frustration set.
This is the moment the judge basically draws a hard line. Police departments exist for emergencies, crimes, and real threats to public safety. They're not meant to referee personal grudges between neighbors. And the judge makes something very clear here. Even if someone is annoying, rude, or trying to provoke you, that still doesn't make a police matter. Walking away was the right move. But turning around and calling 911 afterwards, that's where the problem begins.
To report and tattle as to what just transpired. There's no need for that. That is not the level of which you would need to communicate in with the Riverview Police Department, sir. Because you called in. Did they say that he had committed a crime?
I don't know if they said one way or the other, but they didn't do anything about it, and I do know that. So.
Okay, sir, because sometimes there's not anything that can be done or that needs to be done.
I'm not saying he committed a crime by doing that, but it's still a good idea to let people know when that is occurring.
No, it's not. You want to let somebody know, go right ahead, but you're not calling into the police department to let them know what he just did, or that he's wearing red pants today and you didn't like to see the red pants, or he didn't respond to you when you said hi. Those are things that are not a good idea to call in and say at all. So what else do you think is a good idea to call in and let the police department know?
I know there are any number of things, any kind of violent crime, fire would be the fire department. I wouldn't call the police for that. I would call the fire department for that. I go by my gut feeling on stuff, and when it gets to a certain level, yeah, I'm going to let them know, and that's why I pay out.
Let them know or report a crime. Those are two different things, sir. The Riverview Police Department doesn't need to be in the know every time there's a situation or a conversation that somebody doesn't want on Valade Street. They don't need to have the 411.
You do stuff that would not be as provocative as it is.
You know what
the word that you used was antagonistic. I think that's also a good word as well.
You know what I wish? I wish that the two of you would wear earmuffs and blinders when you're entering and exiting your homes, so that you don't even have to lay eyes on each other or hear the other person. I wish that the two of you...
When the judge hears the estimate, hundreds of calls, you can almost hear the courtroom collectively thinking the same thing. How did it get this far? Because the truth is, these types of conflicts grow slowly. One argument becomes 10.10, becomes a habit of calling the police. And before long, two people who barely know each other are suddenly locked in a years-long feud that controls their entire daily life, which is exactly what the judge points out next.
An emergency situation. Mr. Calipari coming to the edge of the...
I'm sorry, what?
Just turn it off. Just hit the side button.
Sir, I've been there all day.
If he would go to the edge of your driveway, which is the edge of his property line on his grass, is that considered an emergency?
Not to me.
Right.
That's a little outside the scope of this, but those are examples.
Okay. And sir, from what I read and reviewed, it appears as though there hasn't been any specific blocking of your driveway. There may be a slight, what's the word I'm thinking of? Interference with the plane of your approach, of one of the sides of your approach. But it's also important to keep in mind as well, right? When the driveways initially were built in these older neighborhoods, they were built for smaller cars, not necessarily the large cars that we have now. So there's that to keep in mind. Also, when these neighborhoods were built with the streets and the driveways, there weren't 5 cars in each house. So there may be a shortage of parking, and people will try to cram in where they can cram in. Now, if they're blocking the entirety of your driveway, that's a different story. I know the recommendation is fines and costs only, but the court doesn't find that that's appropriate.
Your Honor, in going through this, and I understand, I don't understand the whole thing, to be honest with you. There's been an ongoing neighborhood dispute. Under these circumstances and under these conditions, I believe that that is the appropriate remedy at this time. He has accepted responsibility to the charges. A review of all of the information indicates that this was an appropriate plea opportunity. There's been a complete investigation by the probation department. He's spoken to her. He's relayed the information. I've spoken to Shine about this matter. And based on those conversations, I believe that costs and fines in this matter are appropriate. I understand the pressure or the pressure being placed or was placed on the Riverview Police Department, not only by Mr. Moss, but also by Mr. Kalahari. And I'm going to say this just because I'm going to say this. He's raised this issue a number of times about the parking. I agree with the court that times have changed, and let's be realistic. But even the reports that I read clearly show that Mr. Kalahari is as big an instigator as Mr. Moss is a receiver of that instigation. He knows that if he parks his car even slightly in front of that driveway, it's not because the street is too crowded. It's because he's doing this to intentionally irritate his neighbor. Looking at the reports, and there was in the police report that I reviewed, this incident was a culmination of about 4 other phone calls and incidents. A great deal of it was because of the instigation, if nothing else, of Mr. Kalahari.
Okay.
Let's be realistic.
But let's also be realistic. Just because somebody parks in front of Mr. Moss's house, whoever it may be, who cares?
Your Honor,
it is a public street. Anybody can park there unless you have a handicap reserved parking spot that's specifically for you. Who cares who parks there?
Your Honor, that's not what I'm saying. I'm saying that Mr. Kalahari, if John Goldpo went there and accidentally or parked there because it was a crowded street, he wouldn't be calling the police.
I know that.
But
so who cares who it is, whether it's Mr. Kalahari or anybody else? Why do you allow that to bother you?
I'm not just talking about in front of my house. I'm only talking about to the edge of my driveway.
Okay, we know that.
Even if it's to the edge of your driveway.
Your Honor, it's not because of the...
It's because of the person that it is.
It is because of the person. And that person is doing it to aggravate and intentionally cause Mr. Moss to react.
Okay.
And how's the reaction? Hey, I can go out there and punch the guy in the face. That's not a good reaction. Or I can call the police and say, this is...
That's also not a good reaction because there does not even rise to the level of contacting the police. And let me just say this. Let me just say this. Let me say this, Mr. Moss.
The ending here is actually surprisingly thoughtful. Instead of just punishing the behavior, the judge gives advice. She mentions something called the let them theory. Basically the idea that sometimes the best way to deal with difficult people is to simply stop letting them control your reactions. Because the moment someone's behavior dictates your day, your emotions and your actions, they've already won. And in this case, the judge seems convinced that both neighbors allowed that rivalry to take over their lives. Sometimes justice in court isn't just about fines or punishment. Sometimes it's about forcing people to finally let go of a fight that never should have lasted this long.
Of a lot of your day.
It actually isn't.
Okay, well.
I don't try to give him 2 cents worth of thought, frankly, When he tries to force conversation upon me, that which I'll grant this. Ever since your order, even before you ordered him on Monday to not talk to me, he has not. I couldn't even tell you the last time he talked to me, and it's been a godsend and one heck of a relief. I will.
Thank goodness. Thank goodness.
If that were to continue, that would be fine.
Well, that's great. However, right, you can't be under court jurisdiction your entire lives.
Right.
So, you know, I don't know how that I don't know how that continues, right?
Same here.
But I will note that it's not all Mr. Calipari, because the video you submitted to the court, maybe on the other one, because he's got Mr. Moss has this exact same charge still pending on another matter. But the video you sent in, you're standing on your driveway videoing Mr. Calipari's house.
I'm pretty sure the day that video was out, that's why I can't comment, and that's why I didn't comment on that day, because there have been a number of videos. If he wasn't in the shot, it was probably because he likes to have his chair turned towards my house, and that's probably what I was shooting, but I'm having to speculate as to that.
Sir, he can have his chair facing whatever way he wants it to face. He can have it face the moon. Who cares where it's facing? Who cares where it's facing? If you don't want individuals to turn and face your house, go buy 10 acres somewhere and go move there. That's the only way that you're going to resolve that issue of people looking at your house or looking at you or looking at your car or your driveway or your brick or your garage. I don't know. But then he's looking at you or he's facing the chair in your direction. Who cares? Your response to that was to video him. Mm-hmm. How immature is that? Who cares? Who cares what way his chair is facing? Go in your house where if that was on where you're on your way to, get in your car if that was on your way to, if you're on your way for a walk, continue with that. Who cares what way his chair is facing? Why does that bother you so much, sir?
He doesn't need to have it facing towards my house, especially when he starts sitting in it when the weather gets warm and he starts using it to spy on me. And I don't like that, and he knows it. But you know what? I have a chair too, and I used it a couple of times to face him sitting in his chair, and that drove him inside of his house. So I found that to be very effective, actually.
So I
only had enough time to do it a couple of times.
So we have a chair duel going on.
Of sorts.
Right. How old are you, sir?
55.
Mm-hmm. 55. And Mr. Calipari is what, 65?
70.
70. And this is your behaviors. This is the behavior of both of you. If you don't like having neighbors that close to you, sir, that can look at you and you think they're spying on you, relocate on some land that you don't have neighbors that close to you. That's always an option. But it doesn't matter what way anybody's chair is faced. You don't need to then get out your camera and record them. Because then what happened is that Mr. Calipari exited his house and he was continuing to talk. Even though there was no sound, I don't know what all was said. I can only imagine what was said between the two of you. I don't know, maybe you didn't respond. Maybe he just spent 10 minutes talking without any response, right? But my point is, it's not on Mr. Calipari. Both of you are at fault in this entire disaster of a neighbor relationship. Both of you are at fault. And it stops now. Stop draining the resources of the city that you live in. Counsel, I've heard what you've advocated for your client. This court finds, based upon what it's learned today, as well as what Mr. Moss has indicated about how well things are going with certain conditions in place, the court finds that there is reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Moss and the legislative guidelines. The court's going to order 9 months probation. You're eligible for early discharge. We'll go over that in just a short bit. You are to continue no contact with Mr. Calipari. You are not to contact in to report on what Mr. Calipari is doing or what he said. You are only to contact the Riverview Police Department in the event of an emergency, a medical emergency. You're observing damage to property, right? Damage, like physical damage, not bark on the lot, snow being thrown onto your driveway, whatever that may be. That is not an emergency. And the court's going to also, I'm not going to order as a condition because I don't want it to be deemed as this court promoting one author or person or what have you, but you should really look into that theory and review that. Motivational or inspirational, I'm not sure which description you would want to use, but
Okay.
very helpful review of literature. The court's going to order a $100 fine, $100 screening assessment fee, $450 supervision oversight fee. That's $50 a month at 9 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. Totals $1,075. Going to hold any payment of that into abeyance, sir. We're going to have a review at the end of your probation. We'll see how it goes to see how much of that you actually have to pay of those fines and costs.
Is that like escrow?
No, it's going to be held in abeyance.
Abeyance.
Oh, okay. Well, I'm not familiar with that.
Well, the word abeyance means you don't have to pay anything until you've successfully completed your probation.
Oh, okay.
And
perhaps at the end of that, there may be suspension of fines and costs, depending on how well things go during probation. Okay, any questions?
no, you're right. And
Yes,
you indicated that he would be eligible for early termination.
yes,
And Marcy will explain that to him.
yes. As the court did indicate that you are eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation, all probation requirements.
If you're involved in a dispute with another party such as this and you just can't seem to work it out, don't resort to taking the law into your own hands. You take it to court.